Senate Commerce is now in session. We're going into executive session. I motion to move into an executive session. I have a second? Thank you. We're going to start with HB.
We need to vote.
Oh, I'm sorry. I'm just so excited to move on. We will take a vote into going into an executive session. All in favor?
Aye.
Aye. Opposed? Okay, we're going to start with HB 173, and I make a motion for ITL. Do I have a second?
You have a second.
Any discussion? Seeing none? Okay, all in favor of the ITL motion?
Aye.
Opposed?
Move
Motion.
consent.
Thank you. All in favor of consent?
Aye.
Aye. Opposed? Ayes have it. Senator Innes, since you're
Sure.
into restaurants,
Yep.
you can take it out. Thank you. Okay, HB 182, prohibiting the discharge of volunteer firefighters or volunteer emergency medical technicians from other employment. I make a motion for ought to pass. Do I have a second?
Second.
All in favor?
Aye.
Aye.
Opposed? Ayes have it.
Move consent.
Second.
All in favor of consent?
Aye.
Aye. Opposed? Senator Susie, would you like to take that out?
Certain.
Thank you. Okay. HB 279, increasing the penalty for on-premises license for overseas.
I'll second
I have
that.
a second. All in favor?
We have an amendment?
Oh, okay, we do, and that's my amendment, so I should remember that.
Good job.
Thank you. Let's see. So you can, yes, we do. It should be in front of you on these two pages, this little page here.
Okay.
Aaron had them all. There it is. So we had an amendment because the original bill it didn't increase. They made a mistake and left it 15 days of the original bill.
Gotcha.
And it needed to be increased to 30. So that's all the amendment does.
Your amendment?
Thank you. All in favor of amendment 1536, say aye.
Aye.
Aye. Opposed? Ayes have it.
Could I just ask one question?
Sure.
about the original bill, and I
I'll have to look
know
myself.
this is an important issue and an emotional issue for those that testified.
Yep.
Starting on line 7 for the first offense, the first offense is a suspension up to 30 days. If you're doing cumulative punishment, I think it's currently 10.
But it's up to, and.
Yeah.
And you can reduce the up to if you take the up to can be reduced if managers take part in training. It's really,
That
this
can't
was the
exceed 10.
incentive to get people to do the training.
And as I said, look, I understand the incentive. Could the 30 be reduced to 20 to make it cumulative? Would there be any appetite for that?
Not for me.
Okay, I understand. I just
I'd
raised
stay
the
with
issue
percentages.
because
Yep.
typically penalties increase as they go forward. That's why I
Yep.
raised the issue. But if everybody's comfortable the way it is, I'm not going to be.
I see your point. I'm fine if we want to make that change, if the committee agrees.
All in favor of the amendment as is, say aye.
We did that.
We did.
Oh, we did? I got
Yeah.
it. Okay.
Yeah, because the amendment was on B, which I
Yeah.
agree with.
Okay.
My question, I waited because my question is.
Sure.
A. So if there isn't support for that,
So that change would be on.
line 8 instead of 30, 20, and then keep the rest the same.
And yeah, and I guess, my feeling is that it can still only be 20. It's because it says up to, so it's not requiring 30.
Mhm.
And it does, and this to me is the crux of the bill in many ways, because it does really incent people to take part in the training. That would be as a restaurant owner, manager, staff is really incented to have the staff do the training, and that would immediately bring it down to that 10 days. So,
And just the counter, the only reason I raise it is that for a first offense, which it's a very serious offense, I'm in no way trying to diminish it, a potential 30-day closure, I think most restaurants would not be able to reopen after that. So that was my only concern. But as I said, I respect that this was a very emotional hearing and it's an issue that occurred in my colleague's district. I'm
Any thoughts, Senator
in no
Sharkey?
way trying to diminish.
I do think
Either way.
the up to 30 days kind of captures it, but at the same time, you know, how will it be enforced? Will it be enforced at the full 30 days, which I think is Senator Soucy's concern?
I understand.
And if we specify 20, that might, you know, it's still a very significant penalty.
You know, I think that remains to be seen. I do not want to me, this is just so important. I would, if I had my way and I got everything I wanted, I'd require training.
Yeah.
But the industry has said, please, you know, we don't want the required training. So to me, the compromise then is to say, okay, let's make the training very attractive, recognizing that the penalty may be greater.
Yes, yes. Okay. I mean, I'm okay with the bill as is, but I do see Senator Soucy's point pretty clearly.
Thank you.
Where am I at, Aaron?
The underlying motion is not to pass the amendment.
Okay. Okay. So on the ought to pass as amended, all in favor? Opposed?
Move consent?
Senator, motion for consent, second. All in favor of consent?
I
Senator Shanley,
I will take it out.
thank you.
Okay.
I'm almost there.
283?
Yes, sir. It is 283. Coming up. Okay, HB 283 relative to rental application fees charged to prospective tenants. I was very in favor of them getting their money back. I was kind of shocked that we had testimony that 80% never get their returned funds. So I would make a motion for ought to pass.
Second that.
Thank you, Senator Ennis. A second. Any other discussion? All in favor of the ought to pass motion? Opposed?
move consent.
Second.
All in favor of the consent motion?
Aye.
Senator Sharkey, you want to take that up?
Sure.
Thank you.
Other than the consent.
What's that you do? Okay. Oh, yeah, this is your field.
Right.
Okay, HB 398 is next relative to notice of PFAS contamination prior to the sale of property. I'm sorry, Senator,
Pass?
I'll second it. Discussion, Senator Sharkey?
It's a very important issue. I've been working very closely on this because of the town I represent is highly contaminated. So I'm really happy that we're trying to make some efforts in this direction. And I'm thrilled that we're making a motion of ought to pass.
I have a question, Aaron. I had that, I forgot the amendment. So do the underlying motion, then. Okay, yeah, I would like to move amendments 1553, and you all know that we took,
And I'll second that.
you'll second it. So, all in favor of amendment 1553? Aye. Opposed? Nobody.
And Mr. Chair?
Yes?
The only thing I want to say is I think this is a very good bill. I support it, and I have to compliment the sponsors, the interested parties, all of the stakeholders for working to make this bill, bring this bill to us in this form, because I know the idea has been around for a while, and it's taken a lot of hard work and effort to bring it to this point, so. I just wanted
Thank you. Sharon, we're moving motion as amended.
Yeah, it's not to pass the amendment.
Yep. All in favor?
Aye.
Aye. Opposed? Senator Sharkey, we take this up?
Yes.
Thank you.
Consent.
Oh, did we?
Second.
All in favor of the consent motion?
Aye.
And you got it, Rishardi.
Yep.
Thank you. Okay.
1047.
Oh, some of you remember Senator Jeannie Forrester. She's very involved in this bill. And she asked that we interim study it so she can work on it with others this summer rather than flat out ITL. I had no problem with that.
And this is 1047?
1047, so I would make a motion for interim study.
I'll second that.
Thank you, Senator Ennis. All in favor, or any other discussion? Seeing none, all in favor of interim study?
Aye.
Aye.
I'll take it out.
Move consent.
Second.
All in favor of the consent motion?
Aye.
Aye. And I will take it out. Thank you.
Okay.
Okay, moving along. Lost my master list.
Eleven twenty.
Yep.
1129.
Yep, relative to the authority to vote by proxy in condo associations, HB 1129. Did you have people you wish to speak on this one? Is this the one?
We have someone here, but I mean,
We don't really.
I don't know that it's going to be necessary.
Yep. I'd like to make a motion of ought to pass on 1129.
Second.
Any discussion on 1129? All in favor?
Aye.
Aye.
Opposed?
Move consent.
Second.
Second.
All in favor of the consent motion?
Aye.
Aye. And DeSoucy?
Certainly.
Great, thanks. You're all set. It passed.
Maybe we should, yeah, if you'd like to speak.
We had.
Okay, you can speak, sure.
I mean, we've already voted.
We've already voted and had a public hearing.
We already had a public hearing. I thought, when you came up to me earlier, I'm sorry, I said we were gonna pass the bill. Maybe I wasn't.
So we had the public hearing but this is what passed committee. It'll still go before the full,
Senator,
but
would you like to recess for a minute or two?
Sure.
Why don't we do a 2-minute recess?
Sure.
And
Is that okay, Aaron? Thank you.
Yeah, maybe.
We're gonna take 2 minutes.
maybe Senator Susie could talk about this for a second.
You have to know procedure.
Should be second nature.
So we're doing the liquor store. We're doing the liquor stores, just so you know.
Liquor stores,
On the holidays.
$11.98.
Yeah.
Okay.
What were the 3 holidays you wanted?
Thanksgiving, Easter, and Christmas.
ITL.
All right.
Do you know what I did? He told me at 9 at night. I hadn't even shared transportation. So I watched YouTube's.
Yeah.
That's all you need.
And I got in there and it was like everybody's like, oh my God.
Okay, no, so.
Yeah. I used to have like a
We had done.
Yeah,
They
me
didn't
too.
have any
Oh.
evidence.
I think you're just moving the sales.
We need to
You know,
have this
you're not gonna
right.
sell any more or less.
That's what we're thinking.
It's giving me anxiety.
All right, let's go. She'll come. If you wait on her, she won't.
Tap the gavel.
Shannon? Oh, yeah. Hello. How you doing?
So, yeah,
Senate Commerce is back in session. We're now hearing HB 1198 relative to liquor stores. And the bill was pretty much about opening them possibly, or giving the opportunity to open on Christmas, Thanksgiving, and Easter.
I'll move ITL.
Second. Any discussion? All in favor of the ITL motion?
Aye.
Aye.
Move consent?
All in favor of the consent motion?
Aye.
Aye. Senator Innes, we'll take it out. And do I have a motion to move out of executive
So
session?
moved.
Thank you. We are adjourned.
What maybe I'll-
For this one. Senate Commerce is back in session. We're going to start with 1559. The Honorable Representative Hunt is going to introduce the bill. Good morning, Mr. Hunt.
Good morning. It's always a pleasure to come before the Senate Commerce Committee. For the record, I'm John Hunt, Cheshire 14. This is my favorite kind of bill. It repeals the statute. And the cash dispensing, at one point in time, everybody thought it was a good idea that we know who had these ATMs or cash dispensing. Sometimes weren't really ATM. They were, they weren't banks. They were non-depository or, everywhere. And over the years, we've kind of lowered the fees. We kind of really try to de minimis, try to make it simple, and we're getting to the point where it's just not worth keeping it around. There really is no consumer protection to benefit to know where these machines are, and we don't get too many consumer complaints anyways. So in that case, it was appropriate that we just repeal it from the statute.
Thank you, Representative Hunt. Do we have any questions? Senator Susie.
Representative Hunt, you said we don't get many complaints, and regarding banks, credit union, all of those, I don't. What I've started receiving complaints about are cryptocurrency ATMs. And I wonder if that's something you would be open to, maybe not on this bill, but to at some point addressing.
Well, the problem with doing that is that our bank department does not regulate crypto,
Yeah,
as you know.
I do.
And so therefore, that would be a problem to try to, this would be a square peg in a round hole to try to bring that issue in. That would have to be, you could maybe lift this language and give it to the Attorney General's or the Consumer Protection Division and regulate it that way. But I would, no, you cannot, please don't go anywhere near the banking department when it comes to
It wouldn't,
those
I mean,
machines.
it wouldn't necessarily have to be the banking department, right? But some form of identification of these.
We are very strongly taking a position that crypto is a commodity. It's not monetary. And so therefore, the regulatory authority for any crypto issues would be the Attorney General's office, Consumer Protection.
Okay.
Any other questions? Seeing none, thank you. Does anyone else wish to testify in 1559? Come on up. I didn't see you. Did you sign in? You did, okay. Bob Lamberti. Good morning, sir. How you doing?
Coming with him too. My name's Amelia Galtieri. I'm the bank commissioner for the state of New Hampshire. I didn't sign in separately, but
Okay.
I work with them.
Just when you speak after or before, introduce yourself on the mic.
Sure.
Be great. Thank you. Good morning to you both.
Good morning. For the record, my name is Bob Lamberti. I'm the Deputy General Counsel for the Banking Department. I'm joined by our Commissioner, Amelia Galtieri. I won't take up too much time repeating what Representative Hunt has already said. This bill is designed to repeal the entire statute. We have found, the department has found that the cost to administer the statute outweighs the benefit. In the entire time that we've been charged with in enforcing the statute, in our records, we've only found one complaint. And my recollection is that one resolved without further department intervention. So given that the consumer benefit is outweighed by the cost, we support the repeal. And I would just say that these machines, these cash dispensing machines, will still be subject to the Consumer Protection Act. So that it's not like they'll be floating without any regulation at all. But with that, I'm happy to take any further questions.
Thank you. Seeing no questions, ma'am? Okay, thank you. Does anyone else wish to testify on 1559? Seeing none, it'll end the hearing. Do we want to move back into executive now, since you're here, Donna?
Sure.
We're motion to go back into executive session.
So moved.
Thank you. We're gonna go back and bring up HB 115.
We have to vote on.
Oh, I'm sorry. Aye. Aye.
Aye.
All in favor, that's 5 of us. Thank you. Now I'm going to 115, relative to the termination of tenancy at the expiration of tenancy or lease term. Yeah, do I have a motion? Of interim study?
I'll move it.
I will second it. Thank you. Discussion, Senator Ennis?
You know, conceptually, I like what's happening here, but I think we need a little more time with it, given the housing situation in the state and the low vacancy rate. I worry we could get people crosswise with housing and actually having a place to live.
Thank you, Senator. Any other comments? Okay, on the motion for interim study, all in favor?
Aye.
Opposed? The ayes have it.
Consent?
All in favor of consent motion? Aye. And that's five. Thank you.
Do we want to do the bill we just heard?
No,
No? Okay.
so 115 is all set. I motion to come out of executive session. Hold on. I had said, Senator Ennis.
Okay.
Yep, so we motioned, everyone said out of sec. You ready for the next bill?
Yep.
I'm just gonna get the sign-in sheet. John, you're still here. Good to see you. We're back in session, listening to HB 1241. The Honorable John Hunt is introducing the bill.
Good morning again. I am Representative John Hunt, representing Cheshire 14. Today, I'm very happy to bring to you a new model legislation that takes a whole chapter. You might be aware that in past years, the banking department warned us this was coming, and so it is finally here. And to get through there's a lot of detail here, obviously, but I would say that the Commerce Committee did spend a fair amount of time delving into the bill and some of the different issues. We did have a little bit of crypto issue involved in it. And we also did have some issues dealing with affecting small businesses here in New Hampshire that do payroll. So after all that, we've solved all those problems. So you have here a wonderful finished product.
Thank you, Representative. Do we have any questions? Seeing none, thank you. Robert Lamberti again. Come on down. Morning again, Mr. Lamberti.
Mhm.
This is going to take some time.
Good morning. For the record, again, I'm Bob Lamberti, Deputy General Counsel for the Banking Department. I won't repeat all of what Representative Hunt has said, but just to give you the broad strokes, this does enact it in its entirety the Model Money Transmitter Act. We were before you last year with a smaller portion of this that adopted solely the exemptions that were in the act, and this is the continuation of the effort to get the whole thing passed. The handout kind of goes over some of the major goals of the act in its entirety. I won't get into all the nitty-gritty detail here, but just the MTMA, it's basically a nationwide set of standards and requirements for money transmission. It's designed to protect consumers by establishing sort of a regulatory baseline that is used across the country. And the result is it's easier for companies to engage in money transmission in multiple states. And it's also easier for New Hampshire to coordinate regulatory efforts because standards, definitions, prudential requirements are the same among all the states that have adopted it. As of March this year, by my count, 17 states have adopted the law, and 12, including every state in New England, are currently working to adopt it this year. So just for background purposes. We did have a couple amendments in the House. I think we've resolved all the issues as far as I know that are outstanding, but I'm happy to take any questions the committee may have.
Do we have any questions? Yes, Senator Susie.
May, starting on page 32 and on to 33, I see you're changing renewal dates for all your other licensees. Is that part of
Yes, thank you
a
for the
systematic
question.
change?
Yeah, thank you for the question. That was designed sort of for the department's ease of regulation for our staff so that we can kind of get all the licensees on the same standard for renewal dates alone. It's just an administrative, ease of administration
Thank you.
change.
Thank you. Any other questions? Seeing none, thank you.
Thank you very much.
Does anyone else wish to testify on 1241? Andrew Hosmer. Oh, okay. Thank you. Yeah, I wasn't sure. Thank you. And seeing no one else is testifying, correct? We'll end the hearing. What's that? Okay, I'll be back.
This next one's no short.
Thank you. Okay, we'll start the hearing for HB 1243, an act revising the laws relative to retail installment sales of motor vehicles. It's Groundhog Day, so Representative Hunt, come on down.
Thank you very much. Good morning again. Representative Hunt, representing Cheshire 1214, excuse me. So this, again, another banking department bill. This one affects just the retail sales of motor vehicles. So very extensive, and we were able to, most of the issues have been resolved long before it got to the committee, but it is model legislation.
Thank you, Representative Hunt. Any questions? Seeing none, thank you. Dan Bennett. Morning, Mr. Bennett. How you doing today?
Good morning, members of the committee. My name is Dan Bennett with the New Hampshire Automobile Dealers Association. We're a trade group representing the motor vehicle industry in New Hampshire, about 500 businesses, many of whom are retail sellers. So we're here today to let you know of our support on HB 1243, and we thank our friends and partners at the banking department. A number of months ago, Commissioner Galdieri reached out to us and asked us to work cooperatively on this legislation and get our feedback. It was a real great example of industry and their regulators working together. What resulted was an amendment that was in the House committee to address some of our concerns, and that's as it was passed, and we support them. It may seem odd that industry would support a piece of legislation that allows for enhanced auditing, but in this case, it's our belief that it levels the playing field. And if there are bad actors, they will be held accountable, and this gives them that authority. We support a cleaning up and a modernization of the statute. It provides clarity for us and lets us know how to run our operations. So again, I just like to state that it was a great example of industry and the regulators working together, and we are in fact supportive of the legislation. So,
Thank you, Mr. Bennett. Seeing no questions, go sell some cars.
thank you, sir.
Amelia Galdieri of the Banking Department. Good morning again.
Good morning. For the record, my name is Amelia Galdieri. I'm the bank commissioner for the state of New Hampshire. Thank you for the opportunity to provide testimony in support of HB 1243. I'll try not to repeat anything that's been said, and I have a handout that goes over kind of the highlights of the bill. The main effort behind this bill was to modernize and streamline and make this RSA 361A consistent with our other statutes, easier to administer for both us as well as the people that we regulate. And additionally, it provides additional protections for consumers that we thought were necessary, given different issues that have come up recently with consumer complaints and interactions with the industry. So again, this was drafted with the support of industry, as Mr. Bennett just testified, and I'm happy to take any questions or any follow-up.
Any questions? Seeing none, thank you very much again.
Thank you.
Does anyone else wish to testify on 1243? Seeing none, that'll end the hearing. Oh, we're ahead of time? That never happens. This is back in session. We're going to hear HB
Microphones.
1259, second relative to the property.
Your mic.
I'll start again. HB 1259, an act relative to property and casualty insurance laws administered by the Insurance Department. The Honorable Representative John Hunt is here to introduce it. Go ahead, Mr. Hunt.
And finally, good morning, Representative Hunt, representing Cheshire 14. We would dare say that this is a housekeeping bill in terms of how we are dealing with one of our different categories under the Insurance Department. And this is a property and casualty, not to be confused with health insurance or other categories. You can see that pretty much what we were trying to do is get some new standardized language that is generally agreed upon. Is I always say when I talk about insurance and property casualty in particular, and life insurance coding, is that we always like to be standard language across, so that any company that is interested in coming into Hampshire is not reading something that it's awkward or different, that just gets the guy with the green shades all upset or worried. So if our language is model language that everybody uses, then it ensures that we have a lively, competitive market here in New Hampshire.
I have a quick question, just because I've seen it a lot in real estate things, the language, the specific reason for cancellation or refusal to renew the policy, and that's new. It hasn't been done in the past.
You'll
I've
have
just
to ask
been able
them.
to cancel without.
You have to ask the department.
Okay, we're fine. Okay. I didn't mean to ask. Sorry. Any other questions for Representative Hunt? Seeing none, thank you.
Okay, thank you.
Emily Doherty. Good morning, Ms. Doherty.
Good morning. My name is Emily Doherty. I'm the property and casualty attorney at the New Hampshire Insurance Department. I'm here today with my colleague, Christian Citarella, who's the chief property and casualty actuary. As just was noted, this is largely a housekeeping bill and a modernization bill. It has a number of different parts. The first part pertains to the issuance of personal lines versus commercial lines policies, and the bill just seeks to clarify the line between personal lines and commercial lines insurance. The purpose of the bill is just to better align with the law and with the general practice, and to provide a smooth transition of insurance in the market. The next part of the bill relates to the methods that may be used for audits for auditable basis policies. And the bill just seeks to add 2 additional ways to do the audits. Currently, it can be done by telephone, in person, or by mail. And this just seeks to add electronic communications and virtual means as allowable methods to conduct the audits. The next part of the bill relates to personal lines insurance for property and casualty insurance that's other than automobile insurance. And this just seeks to make it so that in every instance that insurer issues a notice for cancellation or non-renewal, that the insurer has to provide the reasons that the cancellation or non-renewal is being done. Currently, there's another process allowed under the law that potentially the insured has to ask for the reasons, and this just makes it so that in all instances, the insurer has to provide the reasons at the first instance. The last part of the bill concerns adjuster licensing. The department regulates insurance claims adjusters who investigate the claims, property and casualty. Typically, a licensed insurance claim adjuster is needed to adjust property and casualty claims unless it's exempted. This proposal seeks to exclude automobile glass claims as from that requirement that insurers use a licensed adjuster. These are very simple claims and are often very automated, and the department just feels it would be better just to have this exempted from the adjuster licensing requirement. And there's still consumer protection, as if the insurer issued a denial for some reason for the auto glass claim, the insurance company would have to issue a denial letter explaining why, and then also including the department's contact information. So if the consumer had a concern, the consumer could reach out to the department about the denial. That concludes my testimony, and I'm happy to take any questions.
Seeing none, do you wish to give separate testimony? The question again. Okay, you're winging it. Okay. Thank you both very much.
Thank you.
Does anyone else wish to testify on 1259? Seeing none, I feel like Okay, last bill, yay. It's 1178 from the House relative to an employee's unused earned time, which I remember from years past. Representative Cahill. Good morning, sir.
Good morning. I thought we could take time here.
Could take time.
But let's try not to. Thank you, Mr. Chairman, members of the committee. I am Michael Cahill. I represent the towns of Newmarket and Newfields in Rockingham 10. And we are back again in this kind of familiar territory. The bill in its current form no longer has a fiscal note. It has no fiscal impact. And I've made additional improvements as I've learned from stakeholders, issues that were legitimate concerns, such as the university system, which has a, I think, unusually generous package that they offer people if in the event of a layoff. So we now have a 30-day cap on the vacation pay that would be paid to match their program. Also, there are seasonal workers. Mr. Abbott is in the House, and we've talked about how people who pave roads, there's a time when you can't pave roads, the weather or other factors, and so we have a layoff where there's no reasonable assurance of returning to work for that employer. And reasonable assurance has drawn a little bit of concern, but reasonable is all over our RSAs. I provided some information about how the Employment Security views reasonable expectation of return. It's in other bills. We have one coming over from the Senate to our committee, and I just a little word search, and there's I think 16 times when reasonable or various forms were in that one RSA alone. So we want to be reasonable. And it would be nice if people were always reasonable and did the right thing by their employees. Sometimes they don't, and that's why we're here today. We're all used to the idea of an employer having a policy of use it or lose it. Maybe it's the calendar year, you get so many days of vacation, and if you don't use them, there may be the chances are there's a carryover, a limit on that, and beyond that, you lose them. Use it or lose it is not intended to be use it before I do something and take your time away from you. And that's what's happened in a couple of the cases I've cited here. What brought this issue to my attention, was someone that I actually had worked with. And one day I ran into her in the supermarket, as we do sometimes, and she told me that she had been laid off after 7 years of working for this place. And their policy, they had very generous policies as far as having time and using it. And even if you left on good terms, you gave notice, they paid you the time. But in this instance, the requirement was that you had to ask for your vacation 2 weeks in advance, or that's what the policy was for requesting vacation. She was laid off without notice, and therefore she could not request a vacation. And it was $22,350.08 was the value of what her employer kept, rather than paying her what she was owed. I mean, the hours were on her pay stub, and then she's laid off, and that's it. They're gone. And that's because, you have a policy, and we go by practice or policy. And I provided you with her claim and the owner's reply that eligible employees provide at least 2 weeks advance notice of the resignation. Believe me, she did not resign. She was let go. She was laid off because there was a slowdown with the business. But that doesn't justify taking away what someone has earned. The other example is right from my own town. I learned about 5 people working at an assisted living center were lost their vacation time, was on their pay stubs, and then the company changed hands. It was sold. Now, I don't know if you've been through this, but I've been through a company that was acquired, and what always happened, and what a reasonable expectation is that you're staying on with the company as these people did. Your hours will you'll be grandfathered over into the new system. You won't lose anything because the company has changed hands. Now, this is one area that my good friend Chairman Infantine and I agree on, that yes, you should make arrangements if you sell the company or you close the business. We seem to disagree on the issue of a layoff. And I think the layoff is the more common occurrence. And it's another situation where it's beyond the employee's control. You have no advance warning. You didn't say, well, I'm going to put in for this time and the employer will give it to me. Maybe because they whispered in my ear, there's a layoff coming. That's not what happens. You're at work, like you're going to work, you're doing your job, and then, there's a meeting in the break room. And today's your last day, and whatever vacation time you had, if their policy is vacation is not paid out on termination, regardless of circumstances, you lose. And these people working at the assisted living center, they lost several $100s apiece, which in 2014, when this happened, that was a lot more than it is today. But still, you were working paycheck to paycheck, or maybe a little better. Losing that money that you earned is unconscionable. If we have this, we allow it. And in these rare instances where there's a layoff, the company changes hands, whatever like that, that's the only circumstance in which this bill applies. It only applies if the company has 15 or more employees. And I also provided to you information about the frequency that wage claims involve vacation time. I'm not saying they're all like this. I doubt if they are. But when someone takes the effort to contact the Labor Department and arrange a hearing because they lost their vacation time, it's a significant issue. And it tends to be, 25, on average, 25% of their wage claims involve vacation pay. So it's not something we should ignore. It's something we should address. And that's why you see me so often with bills on this topic. I'd be glad to take any questions you might have.
Thank you very much. Very clear testimony. You didn't really read it. 2 thumbs up. Any questions
How
from?
about 5 ought to pass?
Seeing no questions, thank you very much.
Thank you, sir.
Will Infantine. Morning, Representative.
Always kind, Michael. Good morning, everyone. Nice to see you again. My name is Will Infantine. I represent Hillsborough 13. I'm the chairman of the Labor Committee. This bill has come in front of me probably 6 times in the last 8 years. And each time my fellow representative and I have tried to come to an agreement, and we're getting close, but we're not quite there yet. This bill came in front of you, the House last year. It did pass. It did fail here in the Senate, and by House rules, it was allowed to come back, where it came out of the committee 1010 and went to the House floor. It did pass, went to finance. They wanted to interim study and was overturned in the House to ought to pass, and now we're here. One of the things I've learned is in the Labor Committee all these years is that we have a myriad of different businesses in the state of New Hampshire. Ones that I hadn't even thought of. Things I don't even know that things that go on in the state, the things that we make here, the things that we do are amazing when you get down to it. And each business owner has to make changes as the environment changes. Whether we're in a good economy, a bad economy, a pandemic happens, a situation now where we don't seem to have enough employees. So employers make decisions on how they're going to change what they do to stay in business and to garner the employees they need to do what they need to do. Many companies have gone away from the traditional, you have X amount of weeks vacation and X amount of sick time. They put it all together and pay time off. Use it as you choose. Other companies that are seasonal have to make other changes, as was expressed with paving companies. They're down 3 months a year when the paving plants are closed. Some employers will take 2 or 3% of your pay with your agreement, and they will hold that for you, and then you will utilize, and then they will pay you that money out in those months that the plants are closed. There's a chocolate company in Manchester And they retool every July, and they close down for the entire month to retool. They make certain arrangements with their employees. So I have a difficulty trying to put everyone in the same box and say, this is what you have to have, this is what you have to do. Some employers want you to take your vacation time. They don't want you to bank it, they want you to take it. So you're fresh and whatever. And if you're sick, take the time, go get well. Don't put it all together. They don't want you to take this as some kind of a bonus at the end when you leave and pound them out. That's not what it's for. So one of the thing where my colleague and I do agree is that if a company is sold and you continue to work for that company, you should have the same accrued time carried over to the new employer. No questions. I have no issue with that. If a company is going to close, they've made a decision, we've been in business 25 years, we're going to retire. And if there's money there that is accrued for those folks, I agree with that as well. But I have a real hard time when it comes to layoffs because of how each company will deal with it a different way. You know, we have partial layoffs. You can go from 40 hours a week to 20, and unemployment securities will pay you some of the difference. So there's all kinds of mechanisms in place. Reasonable assurance is just too broad for me to be able to wrap my arms around. When you have a hearings officer that has to make a decision on what is a reasonable assurance, I think that's very vague, and it's going to be very difficult for them to continue from one hearing officer to the other to be consistent. I have submitted an amendment which I put forth through the Finance Committee, which addresses the two items, which is if the business is sold or closed down. Those are things I'm okay with. On the unemployment, there are some stories. Yes, no doubt. Nothing is perfect, and no legislation can ever be made to take care of every single circumstance that comes around. You have to let employers do what they feel is best for their business and their employees. And I don't like the wording of this bill, finally, because I believe it supersedes people's employee manuals, and I don't think we should do that as a practice. We don't know how to run their businesses. They do. There's a question of whether this supersedes private union contracts. I've been told no. I disagree. But that's up to lawyers. I'm not one of those. So I have submitted my amendment for your review. Unfortunately, I can't agree with my colleague on the situation with laying offs. I think it's too broad. And like I said, it supersedes people's employment manuals, and I just can't go with that. So thank you,
Thank
Senators.
you, Representative. Do we have any questions? Seeing none, thank you.
All right, thank you. Have a good day.
Dave Juve. Morning, Mr. Juve. How you doing?
Good, thanks.
Good.
Thank you, Mr. Chair, members of the committee. For the record, my name is Dave Juve. I'm a Senior Vice President with the Business and Industry Association. We have a very nuanced position on this bill, and I would like to try and explain how we arrived there. Chairman Infantine mentioned the idea of paying an individual for accrued but unused vacation time is one that has come up repeatedly over the last 10 years. BIA has always opposed that legislation, believing it should be up to the employer to design a benefit package, not the state. After the bill last year died, the sponsor, Representative Cahill, and I had a conversation, and I suggested that he consider, rather than going for the whole apple, to just take a bite of it and look at a baby step. And what I suggested was that he focus on those employees who, through no fault of their own, were in a situation where they had accrued time and didn't have the opportunity to use it. And the three situations we identified were the result of a layoff and I use the phrase a permanent layoff, or if the business closed, or if the business were sold and the new owner didn't recognize that accrued time. Those were three situations I felt that the employee really was harmed through no fault of their own, no decision of their own. Because I suggested that when the bill was introduced, I felt it would be disingenuous of me to oppose that legislation since it was my initial idea to begin with. We certainly don't support it, but we don't oppose it. So I'd like to present how I view this issue. I think on behalf of the employee, it's pretty evident. If you were to pass this legislation, you will be helping those employees who work for an employer that provides vacation time and could potentially lose it if these circumstances were met. That's the positive of the bill. The negative is, as Chairman Infantine indicated, companies handle vacation time and paid off a lot of different ways. Some will identify it as vacation time. Some will allow you to carry it over from year to year. Some have a use it or lose it policy. Some just call it personal time, and it could be used if you're sick or if you need to take your child to the doctor or your pet to the vet or you're on vacation. It doesn't identify just as vacation time. And so if this bill passes, it's going to create, I don't want to say it's going to create problems, but it's going to create issues for some employers. And they are going to have to decide how to deal with that. Conceivably, it could result in less vacation time to the employee. And employers might say, you know, this is just too risky, so I'm going to cut back on that benefit. We don't know. You folks don't know. Frankly, employers don't know. So there is a great deal of uncertainty from the employer community about what to deal with this, how to deal with this bill if it passes. That's the best I can explain it. That's the best I can explain why BIA has a nuanced position on this bill. I'd be happy to try and answer any questions.
Go ahead, Senator Schiff.
Thank you for your testimony. So with the unemployment for the state that it provides, aren't there protections for these employees due to layoffs and so forth?
Well, there's certainly unemployment protections, as you're well aware. If assuming they meet the minimum qualifications, they can file for an unemployment benefit, and that's designed to provide a bridge so that they and their families can essentially survive until they find new employment. That exists. It doesn't really reimburse them for accrued vacation time that they have. It's two separate things. But you are correct. They will, if they meet the minimum standards to collect unemployment, they should receive it for a specified period of time.
Thank you.
Any other questions? Seeing none.
Thank you, Mr. Chair.
Andrea Chatfield. Good morning, Attorney Chatfield. How are you doing today?
Good morning, Senator Gannon. I'm doing great. How are you? I'm going to emulate my colleague, my friend, Mr. Juve, and ask if I could have another witness come up with me. Her name is Nancy Rawling. It's her first time testifying. And so I thought it would be helpful for her to, if I could be beside her. But I'm going to go first. That's okay. And then I will introduce Nancy. Okay. So good morning, folks. My name is Andrea Chatfield. I am an employment law attorney with Sheen Finney, Bass and Green, but I also am the legislative director for the HR State Council. And I'm representing the HR State Council today. I do have copies. Forgot to. Sorry. Let's give you these. So I hopefully won't take up too much of your time, but I thought it was really important to hear the viewpoint of HR, of human resources here today on something that is right in the HR's wheelhouse. And I have been following this bill We did oppose it last year as well, and I really appreciate the work that Representative Cahill has done in trying to craft something that does respond to the concerns of business. And I appreciate that, but as HR professionals, we still have a lot of serious concerns about this bill and still oppose it. And the first reason is the issue that has already been mentioned here about the issue about should the state really be legislating the terms and conditions of these types of policies? One of the areas I practice in is legal review of employee handbooks. And I've done 1,000 of them in my time of practice. The paid time off policies, and I'm going to use that as a general term for vacation, sick, personal time policies, PTOs, earned time, accrued time. It's called a million different things, and there have never been two policies alike. They are definitely policies that HR people spend a lot of time on administering and crafting, and they can become quite complex. And because there's a lot of details that need to be covered in a good written policy for paid time off. I've seen policies that talk about have vacation time bucket, a sick time bucket, a personal time bucket. I also was thinking just now about, I have a client that has a policy called sick/personal time. And the question then becomes, well, is that covered under this? Because even though this bill does exclude sick time, it specifically includes personal time. And personal time is one of those types of fringe benefits that a lot of times traditionally were never intended to be paid out or considered earned. It was a benefit granted by the employer to allow a person an excused absence. It's about absence when that person needs to be away because of a compelling personal reason. It wasn't meant to be something that is earned, more that is granted a permission to be away from work and be paid for it. But I want to also remind everybody here what our current law is. Right now, under RSA 275, we have current laws that talk about vacation time and personal time and sick time, and says they are considered wages when due. And when they're due is dependent upon what the employer puts in their written policies. The statute also requires employers to make sure they have written policies or written notices that they give to employees about the terms and conditions of their paid time off fringe benefits. In addition, the Department of Labor regulations require that employers also make sure they tell in writing form, they notify their employees when they're going to make changes to those benefits, and that those changes are prospective only, not retroactive. So we already have, our current law, I think, really does a balance of protecting employees when they earn that paid time off, but also recognizing that employers should have a lot of flexibility and need that flexibility to come up with the right types of paid time off policies that are appropriate and also affordable. The bill as currently written still raises a lot of unresolved questions. The first is it includes holiday pay, but I'm not quite sure what that means. I mean, I'm trying to figure out how I'm going to advise my clients on how to put together or craft together a policy, because it's unclear to me about whether or not that this bill would require the payout of holiday pay for holidays that have not yet happened or for future holidays, because a lot of times employers will front load a PTO policy that will encompass everything and tell employees, here's your budget, use it as you need to and as you see fit. And it will include the holiday pay and the sick time and the vacation time. Well, I'm not quite sure how that would work with the holidays. I'm going to also just mention that the other unresolved question I've seen this is, what about unlimited PTO policies? Some employers are putting in place, and they're changing their policies to be unlimited PTO. This allows incredible flexibility for employees, eases the administrative burden for employers, but it's not quite clear to me how this bill impacts those policies, because the bill says that in the absence of an accrual system, earned time shall be paid on a prorated basis. So it seems to contemplate something like an unlimited PTO policy, but I'm not quite sure how it would be impacted or how we would come up with a prorated earned time. Finally, I understand the concern about when there has been a change of ownership, when the business is sold. I understand that that is something where employers should not be shortchanged on whatever accrued earned time they have. But the last provision of this bill is problematic because it suggests that, well, it states that employees may consent to have their time transferred to their subsequent employer when there's been a change of ownership. But the way businesses are bought and sold, typically they look first at the value of the business, and that value will include what is the potential liability for earned time and fringe benefits and the cost of those fringe benefits. And a lot of times that's one of the things that are negotiated when they're coming up with the purchase price. Many times, employees do not know that the business has been sold until the deal has been finalized and closed. So I'm not quite sure what this last section does, whether it's giving the employees an option to then say, well, whatever you decided on the purchase price, I want my time transferred to the buyer, or it's somehow giving them an option to not do that. So I'm clear about that, but I also think it doesn't take into account that a lot of times the deal has already been negotiated and closed before employees know about this and could have any say about what happens to their vacation time. So I worry about that too. And finally, I will say there's a little ironic aspect to the fact that the bill says that this time would be paid out on the terms of when there's a layoff or business closure. Layoffs, and Representative Cahill mentioned a situation which was very unfortunate, but it had to do with a layoff based on reduced revenue. Revenues went down. So in that situation, I'm not sure the employer had the money to pay the time. Similar with a business that closes. A lot of times it's closing because it's bankrupt or it doesn't have the revenue anymore. And yet they would still be required to pay out this time. So for all those reasons, HR State Council opposes the bill. And now I'd like to turn this over to Nancy Rowell.
Thank you, Andrea. Thank you for having me. It's my first time here. My name is Nancy Rowell. I work for a company called Skillings and Sons. We're a small family-owned business in southern New Hampshire, and we drill water wells for residential and geothermal heating and cooling industry. We are an employer of about 85 employees, and I'm concerned mostly, other than the fantastic testimony that Andrea just put out. I agree with everything that she said about it. My concern mostly happens with how are we going to administer a policy that we're not quite sure the way it's written. We changed to a PTO, paid time off policy back in 2002 because we felt for our business that was the best way to handle fringe benefits for our employees. And at that time, we were smaller than we are now. It allowed flexibility for people to use their time off how they see fit to do. As I'm sitting there with a new hire, I will tell them, take your grandmother to lunch, PTO, use it for whatever you want to use it for. If we had to separate it out, that would cost significant amount of time in developing a new policy, putting it in writing, getting our payroll company provider to have that policy the way we want it to be designed. As Andrea said, all companies have their own different policies. It's amazing how many there are out there. My other concern is that the state of New Hampshire has always been kind of hands-off with benefits, fringe benefits, other than to make sure that they're in writing and clearly defined for the employee to understand. I feel at this point, if this bill was to be passed, that it would just open up groundwork for more legislation like this to happen. And now it's not always the live free or die state at that point. So that concerns me very much as well. We're also a family-owned business, like Andrea had mentioned about acquisitions and mergers. And if our company were to sell off maybe to the other family members, how that would impact the company as well. So that has me concerned a little bit as well. Other than everything that Andrea said, I couldn't have said it any better than Andrea, in the BIA, as well. So I just want you to consider the impact that it would put out to all employers having to change a policy as significant as time off. Because this is a very, big benefit to offer employees for time off, and they should be having it, and they should be using it. So I don't want a policy to kind of maybe say to employees or employers that, or employees especially, oh, I'm gonna keep that time because if I leave or they let me go, then they're gonna pay me. They should be using their time for rest and relaxation. It's very important this time, especially with our company. We're very seasonal. So in the summer, those guys can work a lot of hours and we always want them to take their time off. So I don't really, I mean, that's, yeah, Andrea said everything else too. So thank you.
I have a
Thank you
question for
having
you,
me.
Ms. Rawl. So do you think your employees understand that they're not banking time, that they get this?
Absolutely.
You're clear
Yeah.
with them?
That's the one policy in our policy and procedure handbook
Yep.
that is multiple pages long that I always go over with a new hire because it is a significant benefit.
Sure.
Outside of health insurance, you know, and things like that. That's probably the biggest benefit an employee can have or an employer can give an employee.
Thank you.
You're welcome.
Any other questions? Seeing none, thank you both.
Thank you.
Okay. Gary Abbott? Gotcha. What's that? Okay. Morning, Mr. Abbott.
Good morning. For the record, my name, I'm the Executive Vice President of the Associated General Contractors of New Hampshire. I come to you today, first, we oppose the House version of the bill. And let me explain, I represent seasonal employers, so we have layoffs. And we feel the language is very vague in the section that talks about, it doesn't say permanent. Even if we had permanent, I testified in the House that that was problematic for us. And in the bill, it says with no reasonable assurance of coming back to work. Well, you get laid off, even if I'm one of the contractors who is seasonal in nature, somebody could interpret that there is no assurance that you would come back to the same company. So it has problems because what it opens the door, and this is why we opposed this bill in previous years, companies have policies. We don't want the state to start writing a company policy for all companies because it just wouldn't work based on the types of different companies that are out there. So that is our major thing. But what we've come to is we do support in the other two conditions, a company closing or a company selling. In those two instances, we agree with most of this bill. And you'll see in my paper, we agree on those two. We don't agree for existing companies and the existing process for layoffs. So I asked the question of my board of directors, how do layoffs work? And they said it's pretty simple. When we lay them off in the winter, they get any earned vacation time when they end and they go on unemployment. And unemployment doesn't start until that time is used as part of the unemployment. So almost all of them said, we're paying whatever they've earned under our company policy at the time of layoff. These cases that you've heard before they didn't earn it based on the company policy, because an employee, if they don't pay it according to the company policy, they can go to the Labor Department and contest and get it back. But if it is not part of their earned process in the company policy, they're not due it. So for that reason, we think layoffs are already covered. Because if they've earned it, they get paid it, it's done. You don't need all this other language that this puts in. what you will find is we agree with the Representative Infantine's amendment. That one makes clear that your time is earned based on your company policy. And in those two instances that are in this, no fault of their own, that a company is either selling or is going bankrupt, it at least puts a priority for those employee individuals to get what they've earned. So we support the Infantine Amendment if you were to go that route, but we don't support the bill as it's come over from the House to the Senate. And with that, I would end my testimony and hope that you either inexpedient to legislate the House bill or you pass the Infantine Amendment, which I think addresses the two issues that are unique.
Thank you very much. Seeing no questions, correct? Have a good day.
Thank you.
Bruce Berkey, last but never least. You're gonna go.
Thank you, Mr. Chairman and members of the committee. My name is Bruce Berkey. I'm with Sheehan Finney Capital Group here in town, and I'm up here before you this morning on behalf of the National Federation of Independent Business, which has over 1,500 small business members throughout the state of New Hampshire. And we are certainly opposed to House Bill 1178 as it is presented to you today. You've heard a lot of testimony, and I'll try not to be repetitive. And frankly, I'd like to try and sort of summarize some of the points. I think the primary point, the very fundamental point, excuse me, is that the state of New Hampshire should not be getting between the employer and the employee. There's been legislation in the past here in New Hampshire, many, many times, relative to right to work. And the state of New Hampshire has repeatedly decided not to get involved in union activity through right to work. They allow those unions to act on their own, have their own approaches. And in this instance, you have businesses, small businesses, medium-sized businesses, large, that have their policies in place that, are dictated to have them by the state of New Hampshire, but the state of New Hampshire allows them the flexibility to design those plans that work best for their businesses and their employees. Because when that employee comes to work at a place of business, the employer and employee agree on what the package is going to be, what the pay rate's going to be, what the paid time off is going to be, what the health benefits are going to be or not. But it is a package that is developed together and is agreed to by both parties, almost contractual. And so I think for 1178 as drafted, it invades that relationship. And while the Infantine Amendment is a step in the right direction, I'm a little hesitant to endorse it, but I will, because I like Will. But I'm a little hesitant to endorse it because it creates that slope, and I'm not sure how slippery that slope is. But it seems to dovetail nicely with state law, and so and with private policies. This new law would dovetail, I think, pretty nicely with private policies. So from that perspective, we would support the bill if it was amended to reflect Representative Will Infantine's amendment that he presented on the House side. If it remains as is, we will continue to oppose House Bill 1178. I'm happy to try and address any questions.
Thank you, Mr. Berkey. Seeing no questions, you have a great day. Does anyone else wish to testify who hasn't had an opportunity, or come on up, ma'am? Yep, have a good day. Good morning. When each of you speak, just individually introduce yourselves as you're going. Red light on.
Oh, sorry.
That's okay.
My name is Lexi Rojas. I'm the director of the Inspection Division for the New Hampshire Department of Labor. And to my right is Attorney Tracy McGraw. She has lost her voice, so I'm here to assist her on this. So it comes in and out.
Okay. One of the first things that we just wanted to talk about here was.
Go way closer.
Okay.
With the mic, pull it close to the whole bottom. There you go. Awesome. Thank you.
One of the first issues we wanted to talk about here was in our review of the bill and of the various changes and amendments that are taken with this bill. It appears from the Department of Labor's perspective that it may be a concept of trying to make use it or lose it a violation of a statute. This way, in this particular case, as Representative Cahill has been presenting, that there are some cases where people have, and I believe Representative Grassley also presented it, where people have had the opportunity to use their vacation time and then there's a layoff. And when that layoff happens, those who haven't used their vacation time or their earned time, they've lost it. It's gone. Or there's that company that has other reason or has other things set up in their employee manuals that talk about use it or lose it, and the layoff comes into play, or has an issue of having a specific amount of time before the actual time taken has to be requested. So that was one of the things that we took out of today's testimony. One thing from the Department of Labor's perspective is we would be able to obviously administer any bill that would reflect that concept to that degree. In addition to this, we do want to point out that, and we've spoken with Representative Cahill about this, that there is an issue with reasonable assurance. What is that assurance? We understand, we've gone through law school, reasonable is everywhere. But what is a reasonable assurance, keeping in mind that any time that there's a layoff, there's no guarantee of a recall. There's no guarantee that the employees who are recalled will accept and return back to employment. What is reasonable assurance? This would be a difficult process for us to be using our regulatory powers in an inspection, and I can let Attorney Rojas speak to that as well. But also in the hearings division, having a hearing officer listen and be able to review the evidence to understand what actually was a reasonable assurance that they were supposed to be returned. In addition to that, the proration issue may come into play as being an issue. There are, and I believe it's been brought up in testimony here, there are a lot of employers that now put everything into a single bucket. I apologize for my voice. There are a lot of employers who put things into a single bucket. Everything goes in there, whether it's sick time, paid time off, earned time, vacation time. And so how would that be distributed? How would the employer consider that in a situation like this where all of those hours are in a single bucket? And I know that Representative Cahill presented the proration concept. It hasn't really been defined sufficiently enough for the inspectors at the Department of Labor to be able to look at payroll sheets, to look at time cards, to understand whether or not that proration exists, whether it was completed, whether it was done correctly. And the same issue would go for the hearing officers. This would be additional information that they would need to understand before they would be able to issue a decision. I also wanted to say that last year we had discussed with Attorney Cahill that we have had a lot of cases come to the Department of Labor, as he has said, where the issue has been the unpaid earned time, where someone is requesting their vacation time upon termination. And hearings were conducted and decisions were issued. In those particular cases, the Department of Labor is capable, so long as we have criteria to follow. The Department of Labor is capable of both inspecting as well as conducting a hearing on whatever issues that may come up in the existing statutes. Attorney Rojas.
And the final point, and this one is there's they're used in the bill. It uses earned time and unused paid time off to appear to be interchangeable, but as we all know, it's statutory interpretation. Courts may read into that a bit. So we're just, consistency for us would be key when it comes to interpretation. And that's, I think, our final point. More? Oh, sorry.
No. With respect to that, in the first part of the bill, you're looking under 35A. It refers to earned time, under unused earned time. But when you're looking at the section under 43, 5A, Roman 5A, it's using paid time off. Consistency is very helpful in the litigation process.
Thank you both. Seeing no questions, you have a great day. Does anyone else wish to testify on 1178? Seeing none, the hearing is over. Seconded. All in favor of motion to adjourn? Aye.